Hello and welcome to this episode of the Diary of a Lawyer. And today I just want to quickly touch on an issue regarding the Unitary patents reform system, which is intended to be more efficient within the European jurisdiction. The first judges were sworn in at the Unified Patent Court, um, Appeal Court in Paris in June, and so the reforms are gaining. I mean, they are making the court gain sweeping overhaul. So, according to media reports such as the Financial Times, the new patent system is aimed at making the protection of intellectual property easier and cheaper uh, in a bid to make it fully operational in Europe um, around this month after what they describe as years of delays. The court is referred to as the Unified Patent Court and has been instituted to play a crucial role in hearing lawsuits regarding a new type of patent issued by the Munich-based European Patent Office that covers 17 EU countries. The EPO, as it's called, will be able to give or grant a single quote unquote unitary patent covering all the countries that have signed up to the UPC, including Austria, Belgium, Germany, France, among others. And he has described the new system, quote unquote, the most significant development since the signing of the European Patent Convention 50 years ago. Now, the change is significant because until recently or until now, patents in Europe have been national in scope and issued on a country by country basis by national patent offices or the EPO, which essentially meant that companies that wanted patents in Europe is ended up with sort of a collection of individual national patents for the same invention. And consequently, legal disputes over alleged patent infringements led to parallel cases in courts across the continent, which obviously leads to confusion and a lack of legal certainty as to what is lawful and unlawful. Now, from June 1st this year, the new unitary patent system will allow companies to apply for one patent and use a single legal system so that any disputes are heard before one court and the Unified Patent Court. Of course, among other issues such as certain legal certainty, it will also cut costs, streamline procedures, and obviously increase transparency. Now, there are some critiques regarding the regime because there will be a transition period of at least 7 years, seems to be a long time, um, during which companies could still use the existing system whilst the UPC is running in parallel. Well, I think during that time, that does very little to minimize the legal certainty and the sort of streamlining of procedures, which it seeks to improve. They'll also be able to take disputes to national courts if they do not want to use the UPC. But according to critics, they say that it remains unclear what will happen after the transition period. Um, Klaus Gabrinsky, the president of the Court of Appeal of the UPC, says that, quote, it's like a one-stop shop. It increases the consistency of patent case law in Europe and increases harmonization. Um, some lawyers have indicated that in extreme cases, one has court proceedings in around 10 to 15 different jurisdictions between the same parties, and so there's the potential for rationalizing these cases to a smaller number. The UPC, among other tools, can issue injunctions against a possible patent infringement, which is seen as a powerful legal weapon when a single court order would cover 17 countries with up to 300 million consumers. The new system is open only to EU member states and has been in the making for some years. And it would appear that the EU is the first to step up, to set it up since 2012 to simplify the continent's patent protection and cut costs for inventors. The court is not housed in a single building, and its distribution system, and the UPC will have a network of local and regional courts, as well as a court of appeal in Luxembourg. The EPO itself is a non-EU body with 39 member states, including Norway and Turkey. And that is typical EU organization. So whilst I think it's welcome that it will simplify issues, but the disparate nature of the various systems and various areas of existence clearly, places some hurdles that is trying to access justice. There also have been disappointment expressed by some lawyers saying that the UK is not involved in such a significant project, and there's a sense of loss and regret among patent lawyers that the UK is not in it, and its judges and legal system can't participate, according to media reports. However, they said that the UK-based patent attorneys can still act to obtain patents through the EPO because of the way that the rules of representation for the UPC have been set up. Now, this means the UK citizens who have European patent attorneys will also be eligible to act as litigators at the UPC as long as they have certain additional qualifications, which most do have. Now, companies also could be wary about using the court initially, according to critics and media reports, because if it appears that they're losing the patent case at the UPC, that could prove a high stakes option, and adverse ruling would be binding in 17 countries rather than in just one jurisdiction. Some of the critics are quoted as saying the downside of any ruling is magnified in that case, and that there are plenty of people who will wait and see how this system develops, quote unquote. Some of the lawyers say that whether the company decides to opt in or out of the UPC may also depend on what sector they operate in and how important patents are to their business model. For some firms, a patent could be invalidated in 17 countries by a single court ruling, says one critic. And it's also a new system with rules of evidence, and it's not unclear how that will work, as is the case in any new legal system, which is already complex. And so some companies could opt out and choose to go through a system which is not. So those are sort of the brief observation in the new Unitary patent reform system that has been set up under the Unified Patent Court Appeal Court in Paris, where the judges were sworn in this month. Obviously, there's some welcome observations, but as in a new system, there are also some folks that are wary of some of the issues around transparency, streamlining procedures, which it seeks to move, and as well as the disparate nature of its various organizations in different geographical locations, and obviously the uncertainty of the new system and the cost that may have, and also the reputation on those and the business costs of those seeking to use the new system. And so there we shall leave it on this episode of the Diary of a Lawyer, and we will speak again. Thank you. Bye.